Can you appeal an arbitration award? It rather depends. First of all, you can agree to have a two-tier arbitration. Traditionally, the commodities bodies in the City of London had two-tier arbitration. So you had a first hearing and then you had a second sort of appeal, which was typically actually a rehearing on the merits of the case. And there are arbitration arrangements around the world where the parties agree that a second-tier tribunal can hear appeals on a question of law from the first tier. In fact, there's a US Supreme Court case called Hall Street in which the Supreme Court was asked to consider what would happen if the parties agreed to have an appeal on a question of law, something which isn't provided for under the Federal Arbitration Act. The Supreme Court said that the US court system itself wouldn't hear such an appeal. In English law, you can only appeal an arbitration award on the basis of an error of English law, and you can only do so if the parties haven't excluded such an appeal, and if a judge finds on a summary view of the papers that the arbitrators either got it obviously wrong or the point is of general importance, and it looks probable that the arbitrators got it wrong. This is a somewhat aberrant view of arbitration. Very few other countries have any sort of review on the merits of the arbitration award as such. Instead, they have applications to set aside the award, typically on the basis that the arbitrator had no jurisdiction or went beyond his jurisdiction, had an unfair proceeding, or conducted an unfair proceeding, I should say, or alternatively issued an award, the enforcement of which would be contrary to public policy. These are the traditional grounds for appealing, if you like, an arbitration award, not really an appeal on the merits, but there's nothing to stop the parties agreeing to such an appeal, but it has to be done privately, apart from in England where actually you can consent to an appeal on a question of law, which could be determined by the High Court here in England and Wales.
So there is stuff above the arbitration that you can go to if there's an issue?
You say that, however, the parties in Sweden, Belgium and Switzerland, if they are all foreign or not connected to those countries, can actually agree not to have setting aside proceedings. Now, that doesn't mean that there can never be a challenge to the award, because an agreement not to have setting aside proceedings does not prevent the victim of procedural unfairness or an award rendered without jurisdiction or an award whose enforcement would be contrary to public policy from raising those defences when an attempt is made to enforce the award against them.